Bom dia a todos. Me permitam falar em inglês, já que nós estamos aqui, muito embora com a maioria da audiência, ou quase 100% de brasileiros, mas como nós estamos aqui em Harvard, enfim, e nós temos palestrantes de língua inglesa, então me permitam falar essas palavras iniciais em inglês. Good morning, ladies and gentlemen. It's an honor to return to Harvard Law School, and especially to moderate the first panel of the third day of this remarkable conference. This has been a unique opportunity to explore topics like anti-corruption, compliance, law and economics, ADR, and so on. I'd like to thank the organization, especially Isabela Ferrari, Eric Navarro, Bruno Bodar, representing the Harvard Brazilian Studies Association, and Fabrício Fernandes de Castro, representing the Federal Judge Association. Today, we'll discuss law and technology. And on this first panel, we have the honor to hear three distinguished speakers that will give important inputs that will help us to navigate through the phenomenon of technology. So I have the honor to introduce the speakers that I also have the pleasure to be friend of, and what really make my job much easier this morning. So we'll start with Professor David Wilkins, Lester Kissel Professor of Law, Director at the Center on the Legal Profession, the CLP, here at Harvard Law School, and Vice Dean for Global Initiatives on the Legal Profession. Professor Wilkins is an enthusiast of Brazil, and recently launched a book about the legal profession in our country, so he's going to speak a little bit more about this book. Ian McDougall, Executive Vice President and General Counsel of LexisNexis. He sits on the United Nations Rule of Law Steering Committee, and is also a member of the United Nations General Counsel Advisory Board. We had also the great opportunity to hear Ian speak in Brazil last year at the Federal Court, at the TRF da Segunda Região. Ian spoke at an event organized by Fabrício, by the time, by President André Fontes. It was a very nice opportunity to hear about the rule of law. And Jim Klotz, partner at Miller Thompson, current Secretary General of the International Bar Association, the largest lawyer association in the world, the largest the legal profession community, and chair of the President's Task Force on the Future of Legal Services. Group that I also have the honor to be part. So Jim is going to address what we are doing at the IBA regarding the future of law, the future of legal services. So let's start our panel. For those who want to make questions, I request for you to download the app sly.do, and you can address the questions through this app. Thank you very much. I'm going to start with Professor David Wilkins. Thank you.
Thank you. Thank you, Bruno. So while Bruno is pulling up my slides, let me first start by saying, I'm so sorry, but no fala português. Actually, not true. I know feijoada, caipirinha, the imported words, but not enough to talk to you in your beautiful language. Having said that, as Bruno says, I do love Brazil, and I've been coming to Brazil before, I'd say, almost half the people in this room were born. You say, no, I was there in 1971. See, you don't have to say who was born and who was not born. You don't have to say that. But I went to Rio and fell in love with Rio, but I also went to Sao Paulo, I went to Manaus, and I went to Bahia, the soul of Brazil. So, yes. Oh, is it not picking up? No. Are you guys okay? Yeah? Okay. Yeah. And I've been coming back ever since, most recently in connection with the book project that I'm going to tell you a little bit more about. But before I give my remarks, I just want to say on behalf of Harvard Law School and the dean and my colleagues here, some of whom are in the room, including Scott Brewer, who's one of my brilliant colleagues, that we're so delighted that you made this journey to come spend this time with us. It really is an honor for us, for our students. There's several of our LLM and SJD students in the room from Brazil and other countries. And it's such an important time for us to have this kind of dialogue, and particularly to have this kind of dialogue with those of you who are judges. And I understand many here are judges at the federal level and also in the state level in Rio. I know we have some lawyers here from law firms and in-house legal departments. But a lot of times when we talk about these issues, particularly the issues that we're going to talk about today around the future of the legal profession, we often don't speak to judges about this. And yet judges are going to play a pivotal role in what that future will be, and how lawyers are changing is critical to the judiciary, because it makes a huge difference in your lives how the lawyers practice law, how they present arguments to you, what they view as their role, how they represent their clients. And so I'm particularly delighted to be talking about this subject with such an interesting group. I've got some prepared remarks here. I think the rest of my terrific panelists do as well. But we really welcome your comments and questions. I know, Bruno, at the end, you're so cool, have an app already. You can submit it through. I'll have to have one of my 17-year-old son to read me the thing from the app, because I don't know how to do that, even though I'm going to talk about technology. If, as we go along, if there are things that you want to stop me and ask questions about, please feel free to do so. And I'm sure that my fellow panelists would say the same thing, because, again, one of the things about globalization is I try never to forget that it's an honor and a privilege that you come to my country and allow me to speak to you in my language. And so if there are things that are unclear, I hope you will stop me so that we can have a dialogue. Thank you. Okay, so I'm going to talk a little bit in a way that I hope sets the stage for Ian and Jim. I mean, the great thing about being the first speaker and being the academic when I have such amazing practitioners who are going to speak after me is that I can just kind of set the framework, and then I know that they'll deliver the real goods. So anything hard, wait to ask them. Okay. All right. So let's start here. I don't know if any of you if this show was ever in Brazil. There's a children's show called Sesame Street, which was very popular in the United States, the parents would show their kids. And in Sesame Street, they had this game. It was called Which One of These Things Is Not Like the Other? It was a way to teach kids how to count, or the difference between animals, or all sorts of things. Well, we're going to play a little version of this game here, okay? So the question is, which one of these things are not like the other? So first, Crowd Defend is an online platform allowing individuals, organizations, and businesses to solicit crowdfunding for socially motivated legal cases. Okay? Second, DYI Nigeria. It's a one-stop online portal for registration, legal needs, and project management for small businesses in Nigeria. Third, this is my favorite, Integrity Idol. It's a social media competition to recognize honest civil servants in Nepal, Pakistan, and Liberia. Apparently, that's a tough competition. I won't ask you. I know you already spoke about Lava Jato, so I'm not going to ask anything there. 5.0. It's an app to allow citizens to rate, review, and track interactions with police, with results made available at no charge to community activists, media, and law enforcement. Okay? Stand-in. This is another of my favorites. Stand-in helps lawyers find substitutes who can stand in for them in court appearances they can't make. So if you're in court in one place in the state of Rio and you're supposed to be in another place for a hearing, you can look on this app It's like Uber, only instead of cars circling around your neighborhood, it has little icons of lawyers who are circling around the courthouse, and you can click on the lawyer's icon. It will pop up with the lawyer's credentials and their availability and their rate, and you can click it again, and it'll put you in contact with the lawyer, and you can tell him or her where you need them to be at what time in which courtroom so that you can get a continuance in your matter. Here's an article, Computers versus Lawyers. Firm leaders expect computers to win. This is an article that was in a lawyer magazine in the United States, and it reported that 47% of managing partners believe that artificial intelligence will soon replace paralegals and eventually first-year associates. Half of them think that. Okay? Here's another article. This was in a UK magazine called The Lawyer, some of you may know. It says, backed by Burford's millions, Housefield stakes a claim in Germany. Burford, as some may know, is a third-party litigation financing company which has just underwritten the opening of a UK law firm in Germany whose sole purpose is to help German companies sue companies who are violating EU antitrust law. Okay? Next, Deloitte. Okay, one of the big four. Deloitte has recently purchased, since 2014, ADT and Conduit Law, which Jim knows are two of the biggest electronic discovery purveyors in Canada, and has formed an alliance with Kira Systems, which is the leading artificial intelligence purveyor in the United States in the legal space. Okay, this is a big accounting firm. And finally, the American Bar Association, our junior brother to the International Bar Association, has issued a report authorizing what are called limited liability legal technicians, which are people who don't have law degrees, but who are authorized to do some forms of legal practice. Okay, that's a lot of stuff. And the question is, which one of these things are not like the other? Here's the answer. As every law professor says, well, the answer is that none of them are different and that all of them are different, right? Isn't that the way your professors talked to you when you were in law school? Okay, what do I mean by that? They're all the same in that they're trying to bring innovation to the legal profession in some way, right? You notice all of those things were about delivering something that is related or akin to legal services, okay? And they're all the same because not one of them is a traditional law firm, okay? Every single thing I had up there is something different than a traditional legal service provider. But they're all different because they're targeting a different part of the legal profession, different parts of the world, and are likely to encounter different kinds of regulatory and marketplace issues. And here's the most telling thing. They're all the same because these things all came across my desk in the last few months. Ladies and gentlemen of the judiciary, this is the world that's coming at you in one way or another, okay? Now, there's a lot of talk about legal startups and even, kind of robot lawyers. And there's a lot of kind of apocalyptic thinking. I don't know, I've been to many conferences, I bet Jim has too and Ian has too, that are called things like the death of big law. For those of you who are in law firms, they're talking about you. Or even more apocalyptically, the end of lawyers, which is the name of a book written by Richard Susskind, Richard's a good friend of mine. He always reminds me that there's a question mark at the end of his book, so maybe there's hope for the law students who are still in the room. Okay. Here's what I think. I think these discussions very valuable, but we need to be careful because I think they both understate and overstate the state of change in the legal profession and indeed in the entire economy. So they understate what's happening because, as in most things, when lawyers talk about things, we put lawyers in the center of the universe, as if the whole world revolves around lawyers. But in fact, of course, we know that what's happening to lawyers is just a microcosm of what's happening in the rest of the world, and the rest of the world is changing very rapidly. So what do I mean by that? Globalization of economic activity. Think about how many of those things I had on the list were from places like Nigeria and Pakistan and Nepal and other countries of the world. And the important movement of that economy from what you might think of as the traditional centers of economic power in the 20th century in the North and West to the new emerging economies of the South and East. I'll come back and talk about more of that later. Second, the incredible rise in the speed and the sophistication of information technology. The thing that I keep thinking about is that 2017, last year, was the 10th anniversary of the iPhone. Before 2007, there were no smartphones. Now, who in the room can imagine their life without a smartphone? Now ask yourself, what is going to be here 10 years from now that you could never imagine today that you can't live without? The final change is, it sounds a little academic-y, but I'm an academic, so I get paid to talk this way. I call it the blurring together of traditional categories of organization and thought as just a very fancy way of saying that things that we used to think of as all separate and distinct are now much more intertwined today than they ever were before. Think, public and private. Okay? In my country, is General Motors our biggest car manufacturer? Is that a private company or a public company after the U.S. taxpayers dump billions of dollars into it? Let alone things like Petrobras or state-owned enterprises in China. Or how about this one? Law versus business. When I was a student in these law school, and by the way, we didn't have fancy buildings like this when I was here, we used to think law and business were completely separate and distinct worlds. In fact, law was sort of the antithesis of business. It was a noble profession. Well, law still is a noble profession, but no one who practices law today will fail to know that it's also a highly competitive business. Okay? Get the idea? Things that used to be separate are intertwined. This is happening throughout the whole economy. Why wouldn't it affect law? On the other hand, when we talk about change, we overstate sometimes the change because we act as though everything should be disrupted and changed. But that's not true. And no one knows that more than judges. You're supposed to be applying and interpreting the rule of law. That implies a kind of continuity. Ian knows more about this than anyone, right? And law should be predictable and stable in important ways, okay? That's important to keep in mind. So the future of legal work is going to be somewhere in the balance of these big forces of change and these forces of continuity. And that's particularly true in a country like Brazil, where things have already changed a lot. So, I run a project which is called Globalization, Lawyers, and Emerging Economies, or Glee, as we like to call it. Some people here who are young enough will recognize that as the name of a popular television show in the United States about a singing organization. I'm not going to sing for you, and I don't wear a tracksuit. Some people got that joke. But I do study how is globalization reshaping the market for legal services in important new emerging economies in the world like Brazil. And the story starts something like this. Beginning in the 1990s, Brazil, like many other countries, China, India, South Africa, opened their economies to the global economy in a way that they hadn't been before. So when you went from military rule in 1988 to civilian rule and began to open up to the world. And this produced two things. One, a huge increase in foreign direct investment into the country. And second, the privatization of some, but not all, state-owned enterprises. Well, when you do that, you get a demand for new law, right? Suddenly you need competition law and investment law and securities law and trade law. And eventually you realize you need new lawyers or lawyers with new kinds of skills who can operate in these new legal fields and interface between the Brazilian economy and the Brazilian law and the laws of global governance or the laws of international commerce. And this, in turn, has created in Brazil and in many other countries like China, like India, like South Africa, the creation of what we call a new corporate legal sector. And what do I mean by that? I simply mean a part of the legal profession that is dedicated to serving the needs of Brazil's rapidly growing corporate sector and foreign investors, companies moving into Brazil. That's led to the development of law firms of bigger and bigger size. Pinheiro Neto used to be the largest law firm in Brazil, and maybe it had, 30 or 40 lawyers. Now there are Pinheiro probably has 400 lawyers, and there are law firms that have 500, 600, 700 lawyers in Brazil. And sophisticated in-house legal departments. It used to be, maybe the light company was the only modestly large legal department in Brazil. Now most major Brazilian companies, whether based in Brazil or multinationals, have sophisticated in-house legal departments. And this new development has put pressure to change on legal education in Brazil. So both the great traditional law schools, like USP and PUC, see, I can talk that talk, but new law schools like FGV. It's also put pressure on the regulatory structure in Brazil. Entry of foreign lawyers is just one issue, but things like advertising and other issues, the size of partnerships, are others. And it puts pressure on the judiciary, because new kinds of cases and new kinds of lawyers are coming in front of you. The GLEE project is designed to study these changes. And we've just published a book, which I'm proud to say I can hold up. It just came out about 2 months ago, called The Brazilian Legal Profession in the Age of Globalization, The Rise of the Corporate Legal Sector and Its Impact on Lawyers and Society. I won't promise it's good beach reading at Ipanema, but I will say it'll teach you a lot, I hope, or you'll find it interesting, about the development of the legal profession in Brazil over the last, say, 25 or 30 years, including things like legal education, pro bono, regulation of the legal profession, etc. We've written similar books about India. There's one that came out last year. There's a book on China coming. And now we're moving to Africa. And yet, notwithstanding all this change, you in Brazil know more than ever how important the rule of law is and tradition and stability. And all of these tensions are going to intensify in the next few years. So, here's the new normal for lawyers. Lawyers have increasingly sophisticated clients who have more access to information and who are demanding lawyers take things that lawyers used to have all nicely bundled together for the lawyer's benefit, and to unbundle them across an increasingly global supply chain, and to ask and to demand that the lawyers bill them not for the cost of the lawyer to produce it, but for the value the client receives. And this has put pressure on the legal profession's business model. So the business model of lawyers was to bill by the hour, okay, and to make money by hiring more and more junior lawyers per senior lawyers. But there's a lot of pushback about this from clients. Our human capital model was only lawyers could produce legal services. But in those things I put up on the first slide, a lot of the people doing those are not lawyers. They may be technology people, they may be economists, they may be accountants, they may be a whole bunch of other people who are delivering services that are connected to legal services but who are not lawyers. Or it puts pressure on our knowledge management model, which roughly speaking in the old days was either go to the library or ask the senior partner. Now, as Jim and Ian will talk about, we have knowledge management systems, big data, information recovery, etc. And finally, I think a lot about how it's putting pressure on our educational model, which is roughly speaking to teach people how to think like an 18th century common law lawyer. There may still be some of those walking around, but the kind of education that people need to operate in this world is likely to be quite different than it was in the past, okay? And this is creating what the business school economist Clayton Christensen calls disruptive innovation. You've probably heard this phrase before, and if you haven't, you're going to hear it a lot. Christensen defines disruptive innovation as when existing patterns of work, organization, and hierarchy are radically transformed in a relatively short space of time. Again, a fancy academic way of saying things change really fast. And they change really fast in kind of 4 steps. First, new competitors arrive on the market, oftentimes selling cheap, inferior products at the bottom end of the market. When they do so, the incumbents basically ignore them. Or they say, good, somebody's doing that low-end work. Okay? The original personal computers were sold in the toy departments. Okay? They had no power or functionality. And the big computer makers like IBM completely ignored them. But then, sometimes, the disruptors move their way up the value chain and start offering services that people want and can use. And sometimes you get a flip where the new way becomes the only thing people want, and the old way just becomes old, and no one wants it anymore. There's a lot of reasons why law is ripe for disruption. So, law is a very conservative discipline, okay? I like to say I'm in a common law country, that in the common law world, you can't say anything new until you definitively prove someone said it before. That's called precedent, okay? Now, I know all the Brazilians are saying, yeah, but we're mostly civil law. Yeah, but you can't say anything new unless Napoleon said it, okay? All right? It's a backwards-looking idea, right? And it's also been a heavily regulated business. Only guess who's in charge of the regulation? Us. Okay? We regulate what the education looks like. We say who can become a lawyer. We say what the standards of practice are, and we get to kick people out. And not surprisingly, we've had very tight rules about competition, about who can practice law and what they can do and whether they can advertise and how they can be hired. But all of this is changing. So I hope that some of you are watching what's happening in the UK. and Ian can talk more about this, where they've deregulated the legal profession in many ways, and they've eliminated the kind of restrictions on the organizational form in which law can be practiced. You can have outside capital into law firms. And it's all being overseen not by lawyers, but by a competition policy expert who has a very different view of how legal services should be delivered than lawyers often do. Okay? And the pace of change is accelerating dramatically. So, I said before, what happens to law is only a reflection of what happens in the broader society. Law is a lagging, not a leading indicator of change, okay? And so I asked a friend of mine who's a very fancy early-stage venture capitalist in technology to talk about the world he sees in the kinds of companies that he funds and the kind of innovation that he sees. And here's some things that he told me. He said, first, we're in an age of digital Darwinism, okay? What does that mean? He said in 1950, the average age of the largest companies in the US, the Fortune 500, was 60 years old. By 2020, the average age is going to be 12 years old. And if Mark Zuckerberg and Sheryl Sandberg keeps talking, that number may go down even more, okay? Sorry. And the people who are running these companies, like Zuckerberg, are really, really young, okay? And increasingly diverse. That's a huge change, okay? Second, there's been a huge generational shift, all right? So millennials, everybody talks about millennials, but there's a whole generation coming behind them, which sometimes are called Generation Z, like they're zombies or something like that. But if you add these two together, if you look at millennials and Generation Z, in the US, they're going to be 50% of the workforce by 2024. Not 2034, not 2044, 2024. And probably in Brazil, which has a very young population, it's probably going to be more and more quickly. And we know that millennials have a different view about work, that they are attracted to different kinds of things. They want more autonomy. They want more control. They've grown up in the sharing economy. And they are better educated than any generation in history. And they have an understanding of lifelong learning. So this is a statistic from the US, but this really surprised me. 39% of all those people in that generation have college degrees. Now, when I went to college, that number was probably more like 20%, maybe even lower. A college degree is now becoming what a high school degree used to be in the United States. And 28% of them have taken online courses, and that number is climbing rapidly every year. And even postgraduate schools, like law schools and like business schools in particular, are moving to a model in which it's more about what we call executive education, meaning people coming back to school after being in the workforce. One of the things I started here, which I guess tomorrow you'll be in our space over at the Center on the Legal Profession, and I started these executive education programs for lawyers, law firm leaders, in-house lawyers, new partners. We're doing ones for government lawyers because people know they need to get education not just all at once at the beginning, but over time. We've had several Brazilian lawyers, and we'd love to have some of you come and join us as well. This, what you're doing, is a part of lifelong learning. And then think about the gig economy, okay? Uber, Airbnb, whatever you think. Here's a statistic. Remote working in the US has gone from 9% in 1998 to 37% in 2015. That's just a huge jump, right, in less than 20 years. And it didn't surprise me that 43% of all Americans have at least one on-demand service on their phone. But here's what shocked me. 29% have done work in the gig economy. It's an $800 billion part of the economy. This is not just a little plaything, okay? This is transforming the way in which we think about work. Okay. But the future is far from certain, okay? So here's some big questions I want to leave you with, and I'd love to talk about. How do you foster collaboration and even innovation in a culture in which everybody's working remotely, transiently, or in a gig job? How do you create culture in that kind of an environment, right? How do societies like Brazil, like the United States, ensure objective standards of quality and protect the public good in a world that celebrates deregulation and creative destruction? Okay? You've noticed, if you've been watching Zuckerberg, if you've been watching Tim Cook from Apple, suddenly it's not just all about the market anymore. And if you've been looking at what's happening in Europe with the new European privacy law, there's a big question about whether we've gone too far on a deregulatory binge, okay? Because we know this, that tradition and stability have important roles to play for both lawyers and clients, and again, nobody knows this more than judges, that law and lawyering are linked to fundamental goods like the rule of law, which we need to have the kind of constancy that you have shown so admirably in Brazil. And I just can't stop and before saying what Brazil has done in this crisis is amazing. And you know what the most amazing thing for me is? No one is talking about going back to military rule. And if this had happened 25 years ago or 30 years ago or in many other countries around the world, that would have been an open source of discussion. And the reason for it is the strength of the judiciary and the independent prosecutors, and why it's such an honor for me to be here with you to talk. It's true. Listen, the other thing is people make long-term investments. It takes a long time to become a lawyer, or to be good at being a lawyer, to be good at being a judge. You have to protect those long-term investments if you want people to make them. Okay. And finally, how do we protect those who lose in the sharing economy? This is making winners, but it's also making losers. All right. Answering these questions is going to make us have to think hard about what's valuable about our traditions while understanding the change that's happening. We can't shut our eyes to change, but we also have to be self-conscious about how we embrace change and how we try to direct change. These are really hard questions, which is why I'm so excited I could turn it over to them so they can help us answer it. Thank you very much. Thank you.
Well done. Putting that on, Ian.
Okay, thank you for this opportunity to be able to talk to a fantastic audience. You know, part of the talk that you've just heard left me disappointed, and here's why. Because usually I try and make it my sort of personal mission to try and disagree with other panel members. I always think, I always think it's more interesting if you've kind of got some kind of disagreement going on. Disappointingly for me, I kind of agree with practically all that I've just heard there. So let me then try and approach it from a kind of slightly different perspective. I start by saying that LexisNexis, for those of you who don't know, is one of the world's largest providers of information and technology to the legal profession around the world. We're not so big at the moment in Brazil, which is a disappointment, but we're doing our best to change that. Part of that is a very substantial project involving artificial intelligence. And I am going to, first of all, call it an artificial intelligence project, because that's the buzzword of the moment. But I do want to talk to you, focus my talk on the impact that technology will have on the legal profession, and indeed on the judiciary. And I've separated them deliberately there for a reason which I'll come back to. First of all, what I wanted to talk about is what is artificial intelligence. It is, as I say, a constant refrain. Now, many people talk about it in terms of things like machine learning or natural language processing or other kinds of technologies. I actually have a different approach to this, which is not an original approach. As the professor said, we are very reluctant to do something original in the legal world. I'm actually going to quote Professor Turing, Alan Turing, who in a seminal paper in 1950 created something which became known as the Turing test. And the Turing test is not a technology discussion. It is actually a user experience discussion. Yeah. What Professor Turing said was, in certain circumstances, would I be fooled into thinking that I was dealing with another human being instead of a computer? So, for example, I might construct a blind test where I am interacting with two different or multiple different operatives, and I go through this interaction talking about anything. I could be talking about soccer, whatever it is. And at the end of the day, I would be unable to successfully tell which one of those interactions was with a computer or not. That's really important because what it means is that effectively, it means a number of things. The first thing it means, of course, is that it isn't a technology-focused definition of artificial intelligence. It's a user experience way of looking at it. The other thing, of course, is that we are still many, many, many years away from being able to interact with anything that would convince us that it is a human being. Because Turing said, the question is, can computers think like human beings? And it's an impossible question to answer. It's something we can never know. I don't know whether you're thinking like a human being. And many people, talk, for example, about the idea of one day having a robo-judge actually deciding a case. Well, the question goes, how on earth will we know the reasons why this judge is making a certain decision? Yeah. I have a simple answer to that question. The same way that we know the human judge has made a decision, which is by the output. Because when a judge writes their judgment or their decision, that is the output from the judge's deliberations. I actually have no idea what went on in the judge's head. All I know is that there was input and there was output. And interestingly enough, that is almost exactly the same as what a computer does. Now, so here's looking then at the impact that artificial intelligence, or let's go a step further back, that technology is having on the legal profession. Now, we spoke earlier on about data and large amounts of data. To give you a little example, the LexisNexis database is about 150 times the size of Wikipedia. And that contains pretty much an extensive collection of legal knowledge. From the time that a request gets sent to the Lexis database for information, we have technology which enables it to look through this huge amount of data and to deliver a result within about 3 milliseconds of actually having received the request. Now, one of the things that must be apparent to you is you can't do that. There is no way a human can compete with that, frankly. One, the simple mass of information that it's able to store. Two, the way that it's able to filter and respond to requests in this rapid time. You can't compete with it. There is no way you ever will. So, what happens then when this kind of challenge comes along to lawyers, judges, the legal profession generally? Well, once again, I'm going to look at precedent. And I'm going to look back at AI, by the way, has been called the fourth industrial revolution, another buzzword. Well, let me look at the previous industrial revolutions, which are basically steam, electricity, and the microprocessor, for want of a better expression. What happened in those situations? Well, as an example, you generally take the introduction of steam as being certainly in the UK around about the 1840s or thereabouts, and then through successive industrial revolutions. I looked at the unemployment rate in the UK in 1840, and it was about 6.5%. And the unemployment rate at the moment in the UK is about 4.1%. And that is despite all of these things which were meant to have removed people's jobs. All of these things which were automating processes, which were previously done by human beings. Well, so why did that happen? Why did that phenomenon happen? It's because instead of taking jobs away from the absolute pool, what they did was they changed the nature of the jobs that were required. They changed the nature of the jobs such that instead of people doing something themselves, they switched to become doing supporting jobs to the roles that were previously automated. This is a trend which is very clear. In other words, and this is a point you can see me developing now, jobs change, but they don't necessarily go away. Let me give you another example of this. Again, when we talk about the idea that robo-lawyers will come along and replace lawyers. Well, I have to tell you, quite frankly, that the technology to be able to replace all lawyers has already existed for the last 500 years. And it's called a book. And anything I know about the law, you can walk into a public library right now and read. And you have the ability to know everything I know about the law. And as indeed does everybody out there. Everybody walking that street now has right now at their fingertips the ability to replace lawyers. And it hasn't happened. Why is that? Well, nothing rocket science about this. Let me use another precedent for you. As we're in that kind of mood today, I'm going to refer to Adam Smith. And basically what happens is that in societies with any kind of proper functioning economy, there is something called the division of labor. It basically means that people choose how to spend their time. I, for example, do not want to be a plumber. It may surprise you, but I have no interest in the subject at all. But everything that I need to know in order to do my own plumbing is in a public library. And I still don't go to the public library. I employ a plumber to do it. So just to kind of give you a sort of more optimistic outlook with regard to the impact of technology, I do not think, I accept the point that Professor Susskind's statement has a question mark at the end. I do not accept the proposition that technology will ultimately replace lawyers. I simply don't think that's true. History shows us that that's not what happens. History shows us that people generally tend to want to go to someone who has spent their time, effort and money in learning how to do something properly. And I think that will continue. But what will change for, first of all, lawyers, and then I'll talk about judges. The way that we are currently trained to be lawyers is by learning how to regurgitate vast tracts of law, which we commit to memory, and then splurge onto a page in a great big feast at the end of a course. As I've said to you before, the systems that we have and that others have can do that way, way better than you. Yeah. Frankly, the time is coming where the ability to remember large amounts of law will be utterly useless. It will be a skill which you can't compete with because other people will have retrieval systems that can do it better than you. So that won't be your value. You're going to have to move up the value chain. Basically, the way that lawyers will be, I believe, trained in the future is that they will have to learn how to interact with technology. They will have to become experts in how to get the best answers out of the technology that they are using to support their job. Now, what does that mean? In a world where I don't actually have to now remember encyclopedias of information to become a lawyer, what does that mean? That means, of course, that the education establishments are going to have to change. The courses that are run in law faculties such as this one are going to have to fundamentally change and reshape themselves for the technological world in which the modern lawyer will work. The modern lawyer will still have to handhold a lay client through a process. The modern lawyer will still have to run the file and actually be the liaison between the lay client and the legal world in which they operate in. I still think that will continue to happen. But they'll be doing so through the medium of technology that is helping them every step of the way. How then will a person be trained? Well, I think professionally trained. Well, again, I'm going to call on precedent. And in answer to the question about how does the world operate in this very diverse kind of unconnected, unpersonally connected type of way that you heard introduced, I think there is an answer to that, and we've already lived through it. Let me take you back to the way in which, for example, Abraham Lincoln learned how to become a lawyer. Abraham Lincoln did not spend years in a university. He spent years sitting next to a lawyer who knows how to practice and basically learned on the job. Of course, he read books and became knowledgeable as such, but fundamentally the way that people became lawyers back in those days was that they sat next to experienced lawyers for years. It's a funny old-fashioned word that we've lost the use of now, but it used to be called an apprenticeship. And that is how people, I believe, will end up actually being trained. They will go to universities and the like to learn the fundamentals, to learn how to interact with technology, and then they will have to try and find themselves a place with an experienced and practicing lawyer, and they'll have to do a long apprenticeship. That's fundamentally how I see that developing. I refer to that as the celebrity chef model of being a lawyer. And here's why. You will see the celebrity chefs. How do they become a celebrity chef? Well, what they do is they spend time having worked in the kitchen of another celebrity chef. And they have on their CV the fact that they spent 18 months in Gordon Ramsay's restaurant, or 18 months in, I don't know, any of the others that you care to mention. And that gives them the platform to then go out and become celebrity chefs themselves. I think when you have a superstar lawyer, all of the people that work with that lawyer as apprentices will put on their CV that they worked with that lawyer, and that will be their career escalation. I refer to that rather jokingly as the celebrity chef model. As I said, education will have to be technology focused and leading clients through the process, as I've said. Now let me turn briefly to the impact on the judiciary of technology. And right now I'm not talking about artificial intelligence in the sense of a judge having to sit there and guess which one of the advocates is not a human being. I don't mean that in any sense. I mean, let's go a stage before that and think about how technology actually will impact what a judge does. We currently, that's to say Lexis currently has technology which enables us to analyze what, particularly in the common law, because of the lengthy judgments written, to analyze what kind of arguments will be most successful against which type of judge. We have the technology to work out, for example, that Judge A, in cases where the claimant is claiming a certain type of claim, finds for the claimant in 76.5% of cases. We have the ability to textually analyze pleadings such that we can work out which particular arguments are more effective against which particular judge. Now, the interesting conundrum, which I'm going to just leave as a question for those people who are judges or have an interest in being judges, is What is going to be your response when you find out that data about yourself? What will be the response of a judge who finds out that 78% of the time they are finding for the claimant? Will that affect their decision in of itself? This is the interesting aspect that many judges are going to have to be faced with, because this technology is already available now and is already being used in certain circumstances. So turning finally then to regulators and the regulatory environment, particularly in common law countries, the regulatory environment is notoriously slow. There is a long history of waiting for a disaster to happen, waiting for a judge to first of all lay down some kind of principle before the legislature actually acts and tries to put into place some kind of a system. Now, the reason why this may well not be the case so much in the future of the legal profession is because, as has been said, the legal profession is one of those fairly rare, if not unique, situations where it is a self-regulating industry. And traditionally, lawyers have regulated the industry for lawyers' benefit. That is fundamentally the way it works. This is why ownership models have been so restrictive. This is why the access to the profession has been so restrictive. It's because basically this is a private club and lawyers have been very happy to keep it that way. Well, in a world where technology is disintermediating, apologies to the translator for that one, the different chains, what's going to happen is that as these get split up and technology innovation comes in, customers are going to demand that access to this kind of technology. It's better, faster, cheaper, whatever the reason is. And the legal profession will have a choice. It will either recognize that it now has to focus on what the customer wants instead of what the legal profession wants, or the politicians will come along and take the power of regulation away. And this is an important development that I think will happen, and it's interesting because this is being driven by technology. The technology, the efficiency gains, which is, frankly, the legal profession is reluctant to adopt, is being driven, again, from outside. Increasing pressure will come on to the profession in that way. And finally, I then want to come back and just show how this whole thing is full circle again, in answer specifically to the question about how we operate in a world where everyone is remote from each other. Let me take you back again to the world of Abraham Lincoln, and a world there where everybody was remote from each other, and really the amount of travel that people did and the amount of connection that they had was very, very small. All that's happened now, as I see it, is that same kind of environment is being created, except the methods of communication are so much quicker. So I do think it is possible. I think the internet is not a thing as such. The internet is a connection mechanism. It connects a need with a service. If we take, for example, Uber. Uber is not a taxi company. It's a complete mistake to think of Uber as a taxi company. Uber is an online platform which connects a want with a supply. That's all it does. The same thing for Airbnb and various other new technologies that have arisen. Uber does not, or at least allegedly claims that it does not own the taxis that it operates. It simply is a conduit. And so the internet will continue to be that conduit and the platform upon which technology is developed to enable the connection of a service with a need. And the other interesting thing, of course, coming up is how technology can influence the law and will continue to influence the law is, of course, in the area of cars and autonomous driving vehicles, which, again, is claimed to be artificial intelligence. It isn't. It's just complicated algorithms which are looking at inputs and outputs. I kind of, as you can hear, I'm resisting this urge to label every new technology artificial intelligence. It simply is not. It's a more complicated form of technology that's been in aeroplanes for 30 years or more. But here's the interesting legal conundrum. If the vehicle crashes, causes a crash or causes injury, and there are no internal driving controls, because it's easy to understand that a driver with driving controls ought to still be conscious and ought to still be able to take control of the vehicle if the opportunity arises. But you can imagine a situation where there is no steering wheel in the car, there are no pedals, there is only a device which allows you to tell the car where it should go. Who then becomes liable for the crash that results? And again, you can imagine a situation where the car company is considered to be liable for that, but then the car company says, well, the result of that was a malfunctioning piece of equipment which was supplied by a subcontractor, who in turn says, well, actually, my pieces of equipment are supplied by subcontractors, and I just put these components together, and so on, across a global supply chain, which could go all the way around the world. These are interesting things which regulators are going to experience. So hopefully, what I hope I've said in a kind of interesting way is the effect of technology upon the legal profession as I see it, the effect of technology upon legal education, and the effect of technology upon the judiciary. And with that, I think I will end there. Thank you. Thank you.
Well, good morning, everyone. Unfortunately, I do not speak Portuguese, but I actually do spend a lot of time in South America. I have a home in Uruguay, and I am a landed resident of Uruguay, so I'm your neighbor. It's wonderful to be here. I'm not a plumber either, but I am a partner in a large Canadian law firm, Miller Thompson, where I chair their anti-corruption and international governance group. So I'm really sorry I missed the discussion yesterday, which I had quite an interest in. But I wear another hat, and that is as the Secretary General of the International Bar Association. And in that capacity, I chair a task force on the future of legal services. Okay, good, great. Bob Dylan said it correctly more than 50 years ago. The times, they are a-changing. And he was entirely right. Our profession is not just evolving, it's undergoing a wholesale revolution, in my view. Until recently, we were in something that I call the denial phase. We didn't want to admit that the traditional practice of law was going to change. However, in the past years, we've passed from the denial phase into something that I call the confusion phase. Today, if you ask any lawyer what is their greatest concern in law, he or she will say it's the change that is taking place in our profession. But if you press that lawyer as to what that change is, most likely they will say artificial intelligence. And then if you continue to press them about artificial intelligence, you'll discover that, in fact, they're unable to articulate what really worries them about artificial intelligence. And in fact, the changes that they're concerned about are a great many other things. We are definitely in a period of profound change, and as Professor Wilkins said, that pace is intensifying, and the impact is being felt at every level of our profession. So as a senior representative of the International Bar Association, I need to understand the role that that bar association can play in this change. And in my view, that role is to understand the changes that are taking place and to help our members manage the impact of that change. But managing change is not easy. Who here thinks that they are good at managing change? No one? Ian? Okay, at least one. in an executive class that I taught on strategy, I asked the participants the same question, and most of them put up their hands. And then I asked them to go home and ask their wife or husband to change which side of the bed they slept on. Try it yourself. You'll discover that managing change is actually very difficult. Now, last May, when I was appointed chair of the task force on the future of legal services, we created a 3-phase change management project. Phase 1 was to create a global compendium of change that's taking place in our profession. And my view is that before we can dealing with change, we actually have to have a common understanding of what is changing. And so I went about and spoke with the leaders of every bar association in the world, over 400 people. And what I was asking them about the changes that were concerning them, and what I found was interesting. Almost every single one believed that our profession is undergoing a significant and profound change process. But many bar leaders assumed that the concerns that they had in their country were specific to their own country. And one of my favorites was a bar leader who said, "Our problem is unique in our country. We have the big 4 accounting firms competing against our local law firms." Well, that is not a unique problem. That's actually a problem shared by most countries. So our task force decided to create this global compendium of change, and we decided to do it quickly, within 4 months. We wanted every lawyer in the world to be able, at a glance, to understand the primary changes that are taking place. But some of my IBA colleagues said, it should take at least 2 years to do that compendium properly. And my answer to that was, well, if I take 2 years to create the global compendium of change, it will be 2 years out of date when we publish it. The changes that are taking place in our profession are real time, and we could not afford to wait. So phase 2 of our project was to use our compendium of change to then help us identify the most impactful projects that an organization like the IBA is best suited to undertake. And our phase 3 is simply to undertake those projects. Now, when I was appointed chair of the task force, I made it my mission to speak with as many global thought leaders as I could. I actually started with David Wilkins and Richard Susskind. Over the course of last summer, I asked everyone I spoke to, who else should I speak to? And I ended up speaking with 130 global thought leaders, which is a lot.
Yes.
I spoke with all of the authors of the major books. I spoke with the innovative deans and professors, the bloggers, the legal tech founders, the consultants, the big 4 accounting shops, the entire spectrum of the people that are involved in the change in our profession. And I actually, when I was asking them, who else should I speak to, I had assumed that the number of people involved in really deep thinking about change was going to be in the thousands. But I was surprised to discover that the list actually got smaller and smaller as I talked to more and more of them. And really, it's a small collegial group of I think, only several hundred people, which was a bit of a surprise to me. Now, these very smart people have been thinking very deeply about the future of our profession. And there's a relatively common perspective about the changes that are occurring. So to build this compendium, we engaged Professor Maria Jose Esteban, who's an affiliated researcher with the Harvard Law School Center on the Legal Profession. And she did a literature review of everything that's been written about change in the profession over the last 7 years. She used some artificial intelligence tools to process that information. And she identified the 6 major drivers of change in legal services and the sub-drivers within each of those main topics. And I'm briefly going to describe the results of her study, which since last November, it's up on the board here, but since last November has been available for download on the IBA website. So ibanet.org, you can easily find this study, and it's a fabulous study, and I recommend it to you. After I tell you about what we discovered, I'll then tell you about what we're doing in phase 2 and the projects we're looking at. Now, we lawyers used to sell mystery. That's the way I put it. Prior to the internet, our clients had no idea of what we did, and they had no idea of how we did it. They could not replicate what we did. I actually don't think they could go to the library. I'm going to disagree with you, Ian. I think they could go to the library, but they'd have to spend years there to figure out the law. They could not easily download sample agreements. They couldn't easily locate the top experts across the country. They could not easily get fee quotations from 5 law firms on price. They could not easily access articles, guides, and blogs on the internet from dozens of law firms written for the layperson, and they certainly could not easily find case law. As an extreme example, I have a sophisticated client who used to send me his license agreements for a review. That review would take me about 5 hours to review each agreement. Well, now what he does is he sends me 1 line of an agreement, along with 3 cases on point on the relevant language highlighted. And he asks me to confirm if his view, his interpretation of those 3 cases is the same as his. And that takes me, I can say, a fraction of an hour. It's a significant change. Our corporate clients have likewise become empowered. Most large companies have realized it's cheaper to onboard legal services than to outsource them. And for those services that need to be outsourced, corporations are free to price shop. And for that 90% of outsourced work that's not bet the bank legal work for which price doesn't matter, legal fees are under extraordinary pressure. Clients, likewise, will not permit us to bill for lawyers with less than 3 years' experience. And at the same time, basic work that we used for training young lawyers, such as due diligence review in M&A transactions, is now a commodity that clients won't pay for. The traditional model is also a bricks and mortar office, where clients come to meet their lawyers in spiffy premises like we see on TV. Except for litigation and other very personal forms of legal services, face-to-face meetings with clients occur very infrequently. In fact, I practice almost remotely, entirely remotely. And with technology, clients call my Toronto telephone number, and they reach me wherever I am in the world. And it looks like I'm sitting at my desk. Which leads to the next aspect of this driver, and that's increased competition. And one of my most interesting calls with a thought leader was to a lawyer in South America who's running what I call a platform law firm. You might call it, others call it a virtual law firm. This fellow has over 50 lawyers working for him, all working remotely. He generates work through his low-cost business law services, many of which are packaged solutions. His overhead is 1/6 of what a traditional firm incurs. Now, I was absolutely fascinated by his approach, and I noted that it was both scalable in size and also in jurisdictions that he could move it to. But I put forward a challenge, one that Professor Wilkins mentioned a few minutes ago. And I said to him, although I'm practically a completely virtual lawyer, I'm unable to train young lawyers. And thus, not everyone in my firm can become a virtual lawyer. And he said, oh, we've solved that problem. If a young lawyer wants to join the platform and practice, say, venture capital corporate law, we'll create a training course for that young lawyer. And we'll charge a fee for that training course. And then after the young lawyer has completed those training courses, we will then charge that lawyer to work with us as our junior on files. And eventually, when that young lawyer, we feel that young lawyer is trained well enough, we will admit that young lawyer to our platform. And that young lawyer can then become a working member of the firm. As Ian said, that's really the old apprenticeship model that we saw from hundreds of years ago. So what the interesting thing was, immediately after this call, I happened to have a partner meeting at my firm. My firm is 550 lawyers, a lot of partners. And at the end of the meeting, when we got to any other business, I stood up and I told the story of this law firm. And because our firm pays articling students a very handsome wage, and then we hire those students back as young lawyers. We also pay them very well. And within 2 years, many of them come and they say, we've decided to leave law. and find go into business or in-house counsel, or they say, we have no interest in becoming a partner at the firm, we're not interested in working 2,000 hours, that's not our lifestyle, and they leave. So, and this South American lawyer, he's taken our model and he's turned it completely upside down. Not only is he not paying those young people, he's charging them for the benefit. So after I recounted this story, my partners met it with scorn and derision. And they said, well, obviously you cannot train a person as well in that way, and so that young lawyer will not be as well trained as we can do, and the regulators will never allow that. And that was the end of that. But what was interesting was what happened over the next 2 weeks. Partners started to appear at my door, and they started to ask questions like, tell us more about how a platform law firm might work. And so you see the process is beginning for lawyers to start wondering about how we're going to compete with our 50% plus overhead against well-trained lawyers operating on a significantly different model. And competing not just against virtual law firms, but against multidisciplinary practices, the one-stop shopping of the big accounting firms, and against an increasingly smaller number of very large global law firms. But competition isn't just at my firm's level. Legal services at the lower end of the spectrum, the billions of consumers who cannot afford the traditional model of legal fees, are naturally driven to new models that provide access to justice with a cost that is affordable to most. And legal services can also be provided without the traditional need for lawyers. Now, when I set up my own firm for the practice of law 34 years ago, terrifying, a senior lawyer told me that the computer that I had on my desk, which, by the way, I did buy at a toy store, was the stupidest thing he had ever seen in a lawyer's office. Now, we've come a long way since then, but recently the speed of change has really intensified. And it's no surprise that, let me just go to these drivers of change. Where's the clicker?
Here it is.
Drivers of change. Okay, I got it. Okay, great, thank you. It's no surprise that the second major driver of change is legal technology development and innovation, which is the subject of our talk today. Our study breaks this down into multiple areas of technology development innovation, including the increased digitalization of the judiciary. It noted that for law firms, the traditional partnership, full distribution of profits model is a barrier for investment in technology. At my own firm, which is a traditional model, I've worried about this for some time. But, big law firms are like amoebas. They generally move in a predictable direction, but occasionally they can simply lurch into a new direction. And at my firm, we've done that. We've started to seriously look at technological solutions and the technological future as a serious risk. And surprising to me, we've been able to change in a fairly rapid way. But technology comes with its own set of issues, including those that are impacting on our core values, ethics, responsibility, and the need to protect confidentiality and data. The third driver of change is regulatory innovations and gaps. And together with the new forms of value creation and technology, regulatory innovations and gaps are primary driving force for the global legal services industry. And on the one hand, we have regulatory innovations, such as those permitting multidisciplinary practices, non-lawyer ownership of law firms, and non-lawyer training and licensing in high-need areas. But at the same time, we have increasingly critical voices as to the regulatory status quo and our challenges to self-regulation. We also have de facto deregulation, particularly in the emerging markets of Asia Pacific, Africa, and Latin America. And for example, multidisciplinary practices have been established in more than 100 countries worldwide. And you can see how this driver of change intersects with the previous two. For example, how do we define when a computer bot program is actually practicing law? The fourth driver of change is the globalization and shift of economic power. And this primarily is the shift of economic power from the countries of the north and the south to the east and the west. South and the east, sorry. Our study notes that there's an increased complexity between the boundaries between local and the global, and the gap between the need for law firms to continue to expand into emerging markets, but their equal need to generate profits. The fifth driver, which Professor Wilkins mentioned, was skills mismatch and legal education reform. And many of the deans and students that I spoke with confirmed that what is being taught in law schools is not necessarily what students need to practice law. That's not gone unnoticed, and the combination of new forms of value creation with technological and regulatory innovations in an evolving global environment have boosted a skills misalignment between legal education and legal practice, and a trend towards legal education reform. And this is spurring the development of a new architecture for legal education with a focus on employability. Now, this issue was a subject of much debate in my own law firm. One side believes that the role of law schools should be to teach the core values of our profession, namely those related to ethics and an understanding of the law and how it's interpreted. And others believe that students should be learning business and accounting skills, multi-jurisdictional skills, communication skills, and programming skills, so that they can meaningfully adapt to the future environment. And last but not least, did I get it up there? Yes. The final driver of change is changing demographics and values. And our study noted a new demographic mix in our profession, changes in gender, race, and generational distribution, and at the same time, a decrease in the attractiveness of the practice of law. It noted the increased importance of professional career satisfaction and well-being. And it noted a significant diversity and inclusion gap which persists in law firms, particularly at the top. And at the same time, an aging population of baby boomers are delaying their retirement and thus creating stress in the legal employment market. And these demographic factors, in conjunction with what some refer to as a decrease in attractiveness in the career of law, are driving two types of concerns. Top talent is shying away from law school, and secondly, the stress on healthcare and well-being of lawyers and students, with the practice of law becoming increasingly more stressful. On a positive note, our study did identify that innovation has the potential to enhance the personal well-being for those working in our profession. Yahoo. So, where does our task force go from here? For phase 2, we divided our task force members into 6 groups. Each group was responsible for looking at one of the 6 major drivers of change and identifying those projects related to that driver that would be most impactful and appropriate for an organization such as the IBA to undertake. We're not finished that phase, but we have produced a long list of potential projects. For example, our task force members noted that accountability and transparency for using artificial intelligence are at the core of legal liability. Ian mentioned that as well. One of the proposals coming forward is to draft guidelines for the use of artificial intelligence with standards for verification of reliability of the software programs. We also recognize that there are ethical challenges related to the use of technology. We need to update codes of ethics for lawyers, and one of our proposals is for the IBA to draft a model ethical guide for the disciplined use of technology. Another proposal is to define a model insurance coverage for the use of technology to cover both law firms and developers of AI. And finally, in direct relation to technology, we must tackle the issue of data security. Perhaps first we'll undertake a survey, and then perhaps we'll develop a best practices guide, or perhaps we will establish a minimum standard for data security for lawyers. Other ideas for us to consider include those relating to fee sharing, non-lawyer ownership, unauthorized practice of law, online services, law firm referral networks, and cross-border mobility. We have an idea to build a longitudinal study to determine what skills are required at each stage of a legal career over the course of many years. And finally, we're looking at the idea of a project aiming at best practices worldwide for the education of ethical standards to law students and young lawyers. Well, as you can see, the easy part was identifying the changes impacting our profession. The hard part is now before us, and that's what to do about it. And that's now our challenge. So let me end on a light note about change management. Yesterday, when I finished preparing my notes for these remarks, I asked my beloved wife if she would mind trying an experiment. I asked her if she would mind changing which side of the bed she slept on. And she replied, "Get a new wife." Thank you for listening to me.
Thank you, Professor Wilkins. Thank you, Ian. Thank you, Jim. 3 outstanding presentations. We are going to have time only for one question, and they made through the app. Okay. So it's to all the speakers. How do you see social media in the law market? Do you see lawyers adopting, or is it still a rejection?
Social media is a fact of life. I mean, again, if you look at the fact that 50% of the workforce, and again, maybe more in a country like Brazil, is going to be people who are millennials or younger, they're clearly going to use social media in the way in which they interact. I think we're a long way from understanding about how to use it and how to use it responsibly and for what it is to be used for. But I teach a seminar on changes in the legal profession, met for the last time last night, and one of the people who actually just happened to be in town is the managing partner of a law firm. It's an ASEAN law firm called Zico Law. And I know Jim knows that it's won the Financial Times Innovation of the Year award in the last, I think, for 2 years, a couple of years ago. And the managing partner came, and what she talked about was everything for their lawyers has to be on an app on their phone. That is, if they want people to actually use it, so that could be about knowledge management, it could be about an intranet, it could be about client communication, all of it has to be on their phone or it's not going to get used. And to cite Richard Susskind again, one of the predictions he made in that book, I think not the End of Lawyers, but the book he wrote before, is he wrote a book in like 1998, and he predicted that within a few years, lawyers would communicate almost entirely with their clients by email. And the bar of the solicitors, the Law Society of England and Wales, basically brought him up on charges saying that he was encouraging the unethical practice of law because email could never be made secure for lawyer-client communications. Okay? How'd that turn out? I think if you begin to think about the things, whether it's social media, Facebook, Twitter, whatever, those things are going to be a part of the practice of law. And the question for Jim is, how do we do that in a responsible way?
Could I just say I'm going to now complain profusely about the social media world. On the one hand, I was talking to the IBA Young Lawyers Forum last year, and I said to them, I'm absolutely staggered at, one, how you seem to believe everything because it appears on social media. I've never come across this phenomenon before. It simply seems to have some kind of strange credibility simply because it appears on the internet. I think we need to kind of dispel this idea and bring in some bit of critical thinking as well. The second thing is, at the moment, people are still learning how to use social media. I mean, it seems to me that for some reason, people feel that posting pictures of themselves staggering drunk out of a bar with their friends is going to be great for their careers. And I've never yet worked out why they think that should be the case. I also have said to many people, if you had a big wooden board outside your house, which could never be taken down and which could never have its display changed, would you post the same things on that big wooden board outside your house that you post on the internet. Very few people seem to want to post the same things on a big wooden board. So anyway, the reason for this little diatribe is because I think that we have a long way to go before we become sophisticated enough to actually be able to use social media either effectively, properly, ethically, or sensibly.
For me, the jury's been out on social media, but recently a certain gentleman on social media made the statement that lawyer-client privilege is dead. And that was a fabulous tweet, because all of a sudden millions of people got to learn that there was something called lawyer-client privilege. And so I can see a positive sign, at least for law, coming from that. And I'll leave you at that.
Okay, thank you very much again, and thank you all the speakers, and it's the end of our session. Thank you.
I thought we went to 11:30.